Hello students, welcome to TSAT. Welcome to TSPSC Group 1 Indian Polity Constitution series. As part of this Polity series, in the last class we have discussed the emergency provisions related expected objective type questions. Today in this class, let us see one more important topic of Indian polity, that is center-state relations. Center-state relations. Center-state relations is very important in a federal nation. In a federal nation. Now, what is the main objective of center-state relations in a federal country like India? To ensure cooperative, coordinative relations. See, there should be a cooperative, a coordinative, center-state relations. And these center-state relations, as per the Constitution of India, is divided into three types. The first one is called center-state legislative relations. The second one is called center-state administrative relations. And third one is called center-state financial. The center-state legislative relations is discussed from Article 245 to 255. Article 245 to 255 deals with center-state legislative relations. Article 256 to 263 talks about the administrative setup between center and states. Administration, management between center and states. And we have Article 264 to 293 deals with financial relations. But financial relations are now focused more on the GST part. Right? The GST part which discuss about GST Council in Article 279 capital A. Article 279 capital A talks about GST Council. Okay. Now, let us continue the class and see important objective type related questions with respect to center-state relations in India. So, center-state relations is a topic where you can expect a minimum of 1 to maximum of 2 questions. Not only that, center-state relation and understanding these center-state relations is very important even for your mains, TSPSC Group 1 mains. In Group 1 mains, there is a short questions on center-state relations. Now, let us focus on only prelims. And now, let us go to the first question. Right. Look at the question, friends. It says, consider the following and choose the correct statement. Statement number 1. Article 245 talks about or deals with doctrine of territorial nexus. Okay. Article 254 deals with doctrine of repugnancy. Both the statements are correct. Answer is C. Now, what is territorial nexus? What is repugnancy? See, Article 245 of the Constitution talks about territorial jurisdiction between center and state. It talks about territorial jurisdiction between center and state. Now, what is the meaning of territorial jurisdiction? What is the extent of the limit or jurisdiction of a law passed by Parliament? Similarly, state legislature law. According to this doctrine, a law passed by the Parliament can be made applicable for the entire country or any part of the country. A law made by the state legislature can be applied for the entire state or any part of the state. There is third one, which Article 245 discuss, that is extraterritorial jurisdiction. So, within India, Parliament law is applicable for the entire nation. State legislative law is applicable for only that particular state. Okay. What about extraterritorial jurisdiction outside India? See, there is an NRI who is in other country, who has the authority to make laws on NRI in India. Who has the authority in India to make the laws on NRIs outside the country? This is called extraterritorial jurisdiction. The power to make laws over the extraterritorial jurisdiction as per Article 245 is with only Parliament. Okay, this is the first one. Second one, what is doctrine of repugnancy? According to Article 254, imagine there is a subject which is passed by state legislature. Subject according to which a law is passed by state legislature. Now, a state legislative law is passed because the president has given approval. Why? Governor has reserved that bill to the president. I will explain in a very simple manner. State legislature has passed a bill. This bill came to governor. Governor reserved this bill to president. President accepted it. Meaning that that bill became an act not because governor accepted, because president accepted. And that law is a state legislative law accepted by the president. Now, when this particular law is in clash with a union law, according to doctrine of repugnancy, this state law will prevail over the union law because it is accepted by president. So, answer is B. Now, let us go to the next question. Yeah, very important for the exam. Consider the following and choose the correct statement. Okay. Under Article 249, under Article 249, if Rajya Sabha passes a resolution by 2/3 majority, then Parliament get authority to make laws on stately subjects. Absolutely correct. According to Article 249 of the Constitution, Parliament can make laws on the stately subject if Rajya Sabha accept a resolution on national interest or in national interest. See, in national interest, if Rajya Sabha passes a resolution by 2/3 majority, then Parliament will get ultimate authority to make a law on the stately subject. Now, a law passed for the purpose of Article 249, for the purpose of Article 249 will remain in force for 6 months. No. According to Article 249, a law passed by the Parliament on the state legislative subject will remain in force for 1 year. Right? So, answer is A. Second one is wrong. Let me explain this again. According to Article 249 of the Constitution, in national interest, the Rajya Sabha can pass a resolution by 2/3 majority. when Rajya Sabha passes a resolution by 2/3 majority in national interest, then Parliament will get a right to make laws on the state list subject. This law made with respect to Article 249 remains in force for 1 year. Okay, so the answer is A. Let's look at the next question. Okay. Which article of the Constitution deals with inter-state council? Now, Article 246 deals with subject jurisdiction. That is, the subjects are divided into 3 lists: union list, state list, concurrent list. You all know this. Article 248 talks about residuary powers. Residuary powers with the Parliament. With the Parliament. Okay. Now, Article 256, it is part of the administrative relations. It is part of the administrative relations. It says the state policies or laws shall be in accordance with union, cannot go against union. Now, what is Article 263? Article 263 talks about interstate council. Look at it very carefully. According to Article 263, the President of India, by a presidential order, can constitute an interstate council for integration of states, for better cooperation of states, for better cooperation of the states and integration of the states. The President, by a presidential order under Article 263 can constitute interstate council, and this was constituted in the year 1990. Okay, the answer is D. Let's go to the next question. Chalo. Try to understand the question. Consider the following and choose the correct statement. Article 250, we have seen Article 249, now Article 250 provides power to Parliament to make laws on stately subjects in case of national and state emergency. This is wrong, because Article 250 says Parliament has power to make laws on stately subjects when there is a national emergency in force. It only talks about national emergency. It nowhere talks about state emergency. It nowhere deals with the state emergency. It talks about national emergency. The law made by the Parliament for this purpose of Article 250 remains in operation for maximum 6 months. After emergency ceases to operate. After the emergency ceases to operate, the law made for the purpose of Article 250 remains in force for maximum 6 months. For maximum 6 months. A law made by the Parliament for the purpose of Article 250 remains in force for 6 months after national emergency ceases to exist. Correct. So, answer is B. Answer is B. Is it clear? See, sir, we all know that even when there is a president rule in the country, Parliament has a right to make laws on stately subjects. Yes, but that is as per Article 356. According to Article 356 of the Constitution, the Parliament has the authority to make the laws on the stately subjects, not as per Article 250. According to Article 250, it is national emergency. It deals with national emergency. It says whenever there is a national emergency in India, the parliament can make laws on the stately subjects. This is Article 250. According to Article 356, the president rule, when president rule is imposed, parliament can make laws on stately subjects. Okay, very, very important. Now look at the next question. Chalo. Look at the next question. Which article deals with statutory grants? Statutory grants. See, a grant is something which is given and which is not repayable, like a gift. See, whenever I use the word statutory, see, whenever we see this word statutory, it is legal. Correct. There are two types of grants. The first one is called statutory grants, and the second one is called just a minute, discretionary grants. The second one is called discretionary grants. Now what is the meaning of statutory? It is must by a law. Statutory grants is given as per the recommendations of Finance Commission. As per the recommendations of Finance Commission, statutory grants are given. Now what is the meaning of discretionary? By will. If Government of India thinks that they have to give more money to a state, they will give. But this is generally given on the recommendations of Planning Commission. And presently there is no Planning Commission. So, Niti Aayog. Now the question is, which article talks about statutory grants? Answer is Article 275. Article 275 talks about statutory grants. Article 280 talks about Finance Commission. Article 282 talks about discretionary grants. Article 282 talks about discretionary grants. 280 talks about Finance Commission in India. Finance Commission is constituted by President of India every 5 years to provide recommendations on the revenue sharing between center and states. To provide recommendations on revenue sharing between center and states. Very, very important. Now let's go to the next question. Chalo. Yeah. Expected important for the exam. Which of the following is or are true? River disputes between the states comes under original jurisdiction of Supreme Court. Finance Commission is a temporary body. I will give 10 seconds for you to guess. I am reading the question again. River disputes between states comes under original jurisdiction of Supreme Court. Finance Commission is a temporary body. I hope you have guessed the answer. Let me reveal the answer first, then explain it. River disputes between states comes under original jurisdiction of Supreme Court is a wrong statement. Finance Commission under Article 280, which is discussed in Article 280, is a temporary body. It's a correct statement. Answer is B. I hope majority of you have kept the correct answer. But how and why? Look at the first statement. I hope everyone knows what is the meaning of original jurisdiction. When you take a case directly to Supreme Court, bypassing other courts, when you file a case directly to Supreme Court in India, when you file a case directly in the Supreme Court of India, that is called original jurisdiction of Supreme Court. Cases like dispute between center and state, state and a state are directly taken to Supreme Court. But as per Article 262 of the Constitution, see Article 262, we have seen Article 263 before, I am talking about 262. According to Article 262, a river dispute between two states should be solved by Parliament. It doesn't come under original jurisdiction of the Supreme Court. The river disputes between the states should be solved by Parliament. Parliament should provide a solution, not the Supreme Court. Now Parliament came with tribunals, fast track courts it is called. Parliament came up with tribunals, meaning a river dispute between states comes under original jurisdiction is wrong. Try to understand this. Original jurisdiction is something when you take a case directly to Supreme Court. Like for example, a dispute between center and state, a dispute between state and a state, a dispute between more number of state and one state, like this. But there are few disputes which doesn't fall under original jurisdiction. 1. River dispute between states doesn't fall under original jurisdiction. 2. A dispute arising out of Finance Commission revenue sharing between center and state. Suppose Finance Commission said give X amount to a state. Center did not give X amount. They gave less. This dispute doesn't come under original jurisdiction of Supreme Court. 3. Imagine there is an agreement. Imagine there is an agreement. In that agreement, it is specifically mentioned that the dispute doesn't come under Supreme Court. Then these type of disputes doesn't come under, cannot go to Supreme Court directly. But out of these three, first two are important. The river disputes are solved by Parliament by a law according to Article 262 of the Constitution. This is the first statement. Look at the second statement. The constitutional body which is temporary in nature is Finance Commission. According to Article 280, the President of India constitute Finance Commission to give recommendations of revenue sharing between center and state for 5 years. Imagine, President of India has constituted a Finance Commission in 2013. Imagine, just imagine, Finance Commission as constituted by President of India in 2013. President of India say to that Finance Commission that I want the revenue sharing between 2015 to 2020. Now President of India say you have been constituted in 2013 and please give me your recommendations by 2015. Meaning for 2 years I will constitute you, you give me the recommendations, that recommendations will be applicable from 15 to 20, right? Now here President of India decides when the Finance Commission should provide the recommendations. Only till then it will be alive. It will dissolve automatically after providing the recommendations. This is your 14th Finance Commission recommendations. 14th Finance Commission was constituted in 2013 and provided recommendations from 2015 to 20. Very, very important. Let's go to the next question. Okay. Consider the following and choose the correct statement. Okay. Article 370 provides special status to the state of Jammu and Kashmir. Absolutely true. We all know it. 2. Article 370 was inserted as a temporary article. You all know that Article 370 provides special status to the state of Jammu and Kashmir through an agreement signed between Dogra dynasty and Government of India in 1948 called Instrument of Accession. But this Instrument of Accession, which was signed between two independent bodies, says Article 370 is a temporary arrangement. There is a promise by Jammu and Kashmir Dogra dynasty that slowly they will have their own constitution and move towards democracy. When Jammu and Kashmir has its own constitution and move towards democracy, Article 370 can be revoked, removed, and provide autonomy to Jammu and Kashmir. But things did not go that way. There's a lot happened with respect to Jammu and Kashmir. But by a presidential order of 2019, India successfully revoked Article 370 and made administratively, legislatively, politically, completely Jammu and Kashmir as part of India. So, but when Article 370 was inserted, it was a temporary article. So, answer is C. Let's go to the next question. Judicial orders, public acts shall be accepted throughout the country in full faith is mentioned in which article? See, Article 371 provides special status to certain states. Article 371D, Article 371E, inserted by 32nd Constitutional Amendment Act 1973, provides special status to AP and Telangana. Article 371D provides special status to Andhra Pradesh and Telangana. E only for Andhra Pradesh. So, Telangana receives special status from Article 371D. After Telangana movement, Jayandhra movement, this amendment was held. Now, what is Article 263? You all know, just before we discussed, Interstate Council. 262, river disputes. So, after a thorough elimination process, you all know the article. Correct answer is Article 261. Now, according to Article 261, all public acts and judicial orders should be accepted in full faith. With a full faith, we need to accept. That is more important. Let's go to the next question. Consider the following and choose the correct statement. Delhi was made a union territory and provided with a legislature according to 69th Constitutional Amendment Act. Correct. And this legislature consists of 70 MLAs. The CM and Council of Ministers of Delhi are appointed by President of India. Yes, absolutely correct. Not Lieutenant Governor. See, this is a union territory. A territory under the union control. So, answer is C. Very, very important for the exam. We can expect one question from union territory this time. Okay, concentrate on it. Now, let's go to the last question, friends. Okay. What are the reasons to establish union territory? Now, what reasons generally the union will consider to give union territory status to a particular region? Political region, cultural basis, geographical basis. Answer is C. See, political region examples are Delhi, Jammu and Kashmir, Chandigarh, etc. Cultural reasons, Pondicherry, Ladakh Buddhism, Geographical regions, Andaman Nicobar Islands, Lakshadweep Islands, you have Jammu and Kashmir again, Ladakh, because of the international disputed regions geography, you establish this as union territories. So the answer is C. Very, very important for the exam. Union territories are very, very important. Till now, we have completed some core topics of Indian polity and constitution. And today we have completed center-state relations. We are left with just few more topics like judiciary, Panchayati Raj institutions, municipalities, and constitutional and non-constitutional bodies. I will see you guys again in the next class with another topic of Indian polity and constitution. Till then, keep revising, happy learning, Jai Hind.